Yuma Lundi, hello, and welcome to the iconic Shrine Dome, the home of science in Australia. My name is Jagadish. I am the president of the Australian Academy of Science, and I warmly welcome you. I would first like to acknowledge and pay respect to the traditional custodians of the lands on which we meet this evening, the Ngunnawal people. It is upon their ancestral lands that the Australian Academy of Science is built. As we share our knowledge, teaching, learning, and research practices, may we also pay respect to the knowledge embedded forever within the Aboriginal custodianship of country. I would like to particularly welcome to the Shrine Dome judges of the High Court of Australia, Chief Justice of the ACT, the Honourable Lucy McCallum, Dr. Kathy Foley, Australia's Chief Scientist, Professor Tanya Munro, Australia's Chief Defence Scientist, President of the Australian Academy of Law, the Honourable Ellen Robertson, Executive Committee members of both the Academies of Law and Science. A warm welcome to you all. We are delighted to be here this evening in collaboration with the Australian Academy of Law. Our joint activities have been inspired by the body of work at the Science Law Interface led by the Royal Society of London. Indeed, it was the leadership of High Court Justice, the Honourable Stephen Gagler, who joins here tonight, who together with my predecessor, Professor Andrew Holmes, established the strong and fruitful collaboration between our academies in 2018. Over the years, we held joint symposia on topics such as the reception, quality, and evaluation of scientific evidence in the Australian courts, future directions of technology and law in relation to artificial intelligence, the science law interface as it relates to climate change, and the science and law of prohibited drugs. In this, our 6th annual symposium, we continue to value the long-standing partnership to deliver symposia about topical science law issues. The need for a stronger and more meaningful dialogue between the science and law sectors is certainly not diminishing. Far from it. Advances in science and technology are rapidly shifting the boundaries of knowledge, and justice systems worldwide continue in their quest to deliver justice fairly and equitably. These conditions demand a deeper interdisciplinary collaboration between our sectors and the creation of a more science-sensitive legal system. The Australian Academy of Science's role as an independent scientific advisor to the second inquiry into the convictions of Kathleen Folbig provides a unique and exemplary demonstration of how the science and justice systems can work together in practical ways to enable evidence-informed decision-making in our courts. This evening, we'll hear from Dame Julie Maxton about the extensive activities she has led at the Royal Society of London, working in collaboration with practitioners of law in the UK. Dame Julie's leadership has not just inspired our work in Australia, but has influenced work in the United States as well. It has been this sustained global leadership that saw Dame Julie this year promoted to Dame Commander of the Order of the British Empire for services to science and law. Congratulations, Julie. Of course, Dame Julie has been a long-time friend of the Australian Academy of Science in her current role as the Executive Director of the Royal Society, the body that founded our own Science Academy in Australia some 70 years ago. Before taking up her position at the Royal Society in 2011, Julie was Registrar at the University of Oxford, the first woman in 550 years in the role. She is an honorary fellow of University College Oxford, a bencher of the Middle Temple, a freeman of the Goldsmiths Company, and a board member of Sense About Science. Originally trained as a barrister at the Middle Temple, Julie combined a career as a practicing lawyer with that of an academic, holding a number of senior academic positions including those of Deputy Vice Chancellor, Professor and Dean of the Faculty of Law at the University of Auckland. Please join me in warmly welcoming Dame Julie Maxton to the podium.
Thank you, Jagadish, very much indeed, and thank you all for coming along tonight. You might have seen that it's snowing in the UK, which made it particularly good to escape on Friday evening and come down here, if I may call it that. So what Anna Maria asked me to talk about was the role and reliability of science in the court system, challenges associated with forensic science and eyewitness testimony, and ways the courts can keep pace with advances in science and technology and the new types of evidence presented in the courtroom. So I'm going to follow that outline, and I will finish up with some remarks about the science and the law program in the Royal Society. I mean, basically, just to begin with, as you've heard from Jagadish, I'm trained as a barrister, and I spent most of my time in practice and in the academic world, and then suddenly found myself 11 years ago spirited away from Oxford by Paul Nurse, the Nobel laureate, to work with him as he took up the presidency of the Royal Society. And when I got there, the Chief Justice, John Thomas, basically said to me, well, now you can do what we've talked about for so long, which is help me at the science and the law interface. And I thought, well, I better get my shoes under the table first before I start anything like that. But now, 10 years on, we've done a few things which I will tell you about this evening. So first, a little bit about the Royal Society. I can't assume people know what the Royal Society is. It's very old. It founded in 1660, as you can see, to recognise, promote and support excellence in science. It's an independent fellowship, and it's committed to innovative scientific research wherever it is found. You can see the crest of the Royal Society, nullius in verba, and the shield is 3/4 empty. So if you're not a Latin scholar, or if you are, you can probably have a good go at that, but it's loosely translated as take nobody's word for it. In other words, find the evidence yourself. And that's also the reason why the shield is 3/4 empty, because you need to go and find the evidence. So, why are National Academies of Science interested in law? Well, everywhere you go nowadays, everywhere you look, you see science advancing at pace. Data science, climate science, generative AI, DNA, ballistics, trace evidence, all the techniques are becoming better and better. And ultimately, they're ending up in various courts, particularly of first instance. And in the UK system, at any rate, and it may be different in Australia, but in the UK system, most people who are judges give up science at about 16. And so 30 or 40 years later, they may end up trying a case where there's developments in DNA, or they have to understand climate science, and they've got expert witnesses in front of them. It can be tricky for judges to come to grips with the complexity of science just on the hoof, as it were. So we don't expect judges to become knowledgeable as scientists, but we think that there's some tasks which can be done in bringing judges and scientists together outside of the crucible of the courtroom so that we can get to better places in many of the difficult decisions which come before the courts. So I want to start with a few remarks on expert evidence and then give you the facts of a famous case in the UK. Now, Hugh, I'm trying to press this button, but it's not moving on. Thank you. So this isn't new, the debate about expert evidence. For over 100 years, judges and others have debated whether it's better to have an expert witness called by the court or whether they should be cross-examined by the parties. We're going a bit fast. In 2011, in the UK, an investigation into expert evidence was undertaken, and the conclusion was that it was being admitted too readily with insufficient scrutiny. And what was recommended was an admissibility test. So in other words, a test before the evidence went into court, which went over how robust it was, essentially, and whether it was based on a body of science which was reliable, reproducible, etc. So there were a number of miscarriages of justice around that, referred to in that report, and its recommendations weren't actually put into effect, but they have been in practice put into effect through practice directions, largely under the Lord Chief Justice John Thomas. So in England and Wales, and of course Scotland has a different system, the expert's duty is to the court and not to either party. And the court grants permission to call an expert only if the expert is reasonably needed. In the USA, there are two major tests. One is the Fry standard, which is focused on determining whether the testimony was generally accepted by the relevant scientific community. And that was a 1923 case, which was based on polygraph evidence. So it tried to keep pseudoscience out of the courtroom by using the test, was it generally accepted by the scientific community? But more recently, as many of you will know, there's the Dobert standard, which focuses on the qualities of the testifying expert and the methods used in reaching a conclusion. Now, to the case, the very famous case in the UK. So Sally Clark was a lawyer, as was her husband. And in December 1996, Sally Clark was at home with her apparently healthy baby son, Christopher, who was 2 months old. Her husband was out at a party with his law firm. Sometime during the evening, Sally found her baby unresponsive and called an ambulance. Resuscitation attempts failed, and the baby was pronounced dead. A post-mortem report suggested death by natural causes and a possible lower tract respiratory infection. Less than 2 years later, in January of 1998, Sally's second baby died at age 2 months under almost identical circumstances. The post-mortem report described signs of recent bleeding at the back of the eyes and in the spinal cord. He was an apparently healthy baby who was carefully observed because his brother had died of what's called a sudden infant death syndrome, or so they thought. The same pathologist performed the autopsy on both little boys and called the police. The police arrested Sally and her husband on murder charges. They quickly dropped the charges against the husband, but accused Sally of smothering the children. Apart from the 2 dead boys, there was no other evidence to suggest murder. Her friends and family praised her mothering skills and her character, and much of the evidence for the prosecution came from the evidence of Roy Meadows, who was a paediatrician. Meadows argued that 2 unexplained infant deaths were extremely rare in a family such as the Clarks. In the 1990s, the incidence of sudden infant death syndrome in the UK was approximately 1 in 8,500 in middle-class families with no known risk factors. He argued that the 2 deaths should be considered as independent events and that the probability of observing 2 sudden infant death syndromes in the Clark family could be computed as 1 in 8,500 squared, in other words, 1 in 73 million. There are various questions around this. One is, can these 2 deaths really be treated as independent? 2 sudden infant death syndrome deaths occurred in the same home under the supervision of the same 2 parents. How likely is it that those are unrelated events? It's not hard to see that these statistics could easily be misunderstood and are likely to be prejudicial. Many people believe that the chance of a rare event happening is the same as the chance of a suspect's innocence. In reality, these 2 probabilities are not equal. Saying that there is a 1 in 73 million chance that the babies died of sudden infant death syndrome is not the same as saying that there is a 1 in 73 million chance that the mother didn't kill them. So in Sally Clark's case, we have 2 extremely rare events to examine. Either the 2 babies died of sudden infant death syndrome, or the 2 babies were murdered. The probabilities of both events are difficult to compute precisely, and both are likely to be extremely small. So we need a reasonable estimate of the ratio. Using UK crime statistics and the exact same reasoning that Meadows used in his testimony against Sally, the probability that 2 infants will be murdered in the same household is 1 in 2 billion. So when you consider the likelihood of 2 sudden infant deaths and the likelihood of 2 murders, the odds of Sally Clark's guilt are very small, about 4%. It is in fact much more likely, about 95% more likely, that the babies died of sudden infant death than that they were murdered by their mother. So if a proper likelihood ratio had been done, then that would have been discovered. So she was convicted and was in jail for 4 years. Her conviction was ultimately overturned in 2003 on the basis of additional medical evidence of a possible bacterial infection in the second baby. Meadows used the same statistical arguments in other similar cases and was found guilty of professional misconduct in 2005, though the verdict was later overturned. Sally Clark died on March the 15th, 2007, from a suspected heart attack, thought to be a result of alcohol abuse. She was 42 years old. She spent the 4 years in prison because neither the judge nor the jurors could correctly interpret the significance of the numbers put forth by the expert witnesses. And if you consider that the whole population of the UK is under 65 million, if you tell the jury that there's a 1 in 73 million chance of this sudden infant death occurring, it's pretty obvious what most people who are not versed in statistics are going to think. So I think the Clark case urges caution when using statistics in the courtroom. There are always two or more sides to the story. Forensic scientists, jurors, lawyers, and judges need to consider the probability of the evidence under the two competing hypotheses. The suspect is guilty or the suspect is not guilty. The ratio of these two probabilities is the likelihood ratio, and it can be approximated if not explicitly calculated. In many cases, high values of the likelihood ratio would tend to support the hypothesis of guilt, while low values would tend to support the hypothesis of not guilty. Armed with accurate understanding of this key statistical concept, courts can prevent wrongful convictions, such as Clark's, through the correct interpretation of evidence. The Clark case was even sadder than it sounds in what I have said, because her father was a policeman, and because she was a lawyer and because her husband was a lawyer, she had a very, very rough time in a women's jail. And as you can see, her whole life was destroyed. Now, I know you've had a case. Hugh, this is not working again, I'm afraid. There we are. So you don't need me to tell you this case, but the interesting thing from my perspective, and what links this slide with the previous one, is the original conviction was partially based on the subsequently discredited Meadows law. And Roy Meadows is famous for saying, 1, sudden infant death syndrome is a tragedy, 2 is suspicious, and 3 is murder. And he gave evidence in various other cases, and 3 other women were released from jail when his evidence was discredited. Now, I know this case has a lot more issues, but my caution is on statistics. So, just want to have a word on memory and eyewitness testimony. Human memory is complex and unreliable, and what we're finding out in recent science advances and advances in DNA, that high rates of wrongful conviction have resulted from eyewitness misidentification. And secondly, the science has significantly advanced our understanding of the contributions and limitations of sensation and memory. And the numbers are quite dramatic, actually. And so, as I've put here, the accuracy of testimony is impacted by a number of things: bias, uncertainty, overconfidence, the interesting relationship between confidence and accuracy, potential contamination, and potential contribution of witness variables, for example, age. So, what else are we finding out about the science? The changing nature of the evidence and limits of detection. So subjective versus objective measurements. There are some people that have been in courts in the UK who are regarded as super recognizers. So these are people who have usually been policemen, and they know faces. And if they look at lots of faces, they can think they can recognize a face that has been seen or that they are looking for. There's no science in that. That's a subjective sort of approach to it. But we're going far more into objective measurements today. So now we've got lots of evidence of ballistics, documents, fingerprints, particles, drugs, DNA, and digital evidence, which are coming in front of the courts. And of course, all the time, and a point that I want to come on to with the Queensland issue about DNA, is that you have the triangle of quality, cost, and time. and how you monitor the evidence around that triangle, it can be extremely important. So in the UK, there is a forensic science regulator, well, again, for England and Wales, because of the different legal systems. And the regulator establishes and monitors compliance with quality standards, ensures the accreditation for those supplying forensic science services, and provides advice and deals with complaints. The forensic science regulator now has what we call statutory powers. In other words, you can enforce the standards on people who are supplying forensic evidence, and this has not been without a big fight. But now we're in a position where the forensic science regulator really has some teeth, and I think that is very good for the production of evidence in court. So I mentioned Queensland. This, you will know, there have been 2 reports have come in on Queensland. And in the second quote, the laboratory has for some time focused on throughput and quick reporting of results to the detriment of high quality science. So cost, time and quality, this was to the detriment of high quality science. The automated DNA IQ method extracted less DNA than comparable manual methods. It follows that samples that were subject to this method of extraction that recorded insufficient DNA for further testing may well have contained sufficient DNA for forensic purposes, so that the evidence available for criminal trials may thus have been compromised and convictions that could otherwise have been secured did not occur. I mean, if this isn't putting a question mark over the confidence of people in the justice system, along with the Sally Clark case and various other cases, and another one I'll come to, I don't know what is. So all things point, I think, in the direction of scientists and judges talking to each other more before things get into court. This is not new. High-quality science underpins proceedings in the courtroom and is vital to maintaining public confidence. That much is obvious. But we need strategic coordination of scientific research for the justice system. In 2019, I was asked to chair a report for the Home Secretary, and in my letter to the Permanent Secretary of the Home Office, I said, government should establish a mechanism for strategic coordination of scientific research for the justice system. This forum would convene stakeholders across the justice system, establishing common agreement on research priorities that can meet the needs of multiple groups and co-creating challenges against which government and additional funding can be leveraged. This independently chaired body, perhaps co-chaired by a recently retired judge and an eminent scientist, would articulate the research needs of the justice system as a whole, working to both advance science and support new applications in the justice system. Unfortunately, in the UK, and I hope it's different here, the department that suffered 36% cuts about 10 years ago was the Ministry of Justice. So the hope of getting anything done from my letter, despite the obvious crying need for some kind of coordination, it simply hasn't happened. But we're not the only ones there. Now you'll notice that on the right, the dark blue book, that came from America. And one of the things I've been doing is working with the National Academy of Sciences in America, where they already have a committee on science, technology, and the law. And it's chaired by a Nobel laureate, David Baltimore, and Judge David Tatel from the Washington Court of Appeals. And the committee, as you'll see, that I've set up in the Royal Society, is similar. They, of course, were first, and I didn't know that they had this committee until I started doing stuff at the Royal Society. But now we're working very strongly together, as you will see. So all the messages were clear. There were real needs in the justice system. There were problems if you got somebody like Roy Meadows, who was a paediatrician, and he was endeavouring to get into statistics, and he got it wrong. And the consequence was Sally Clark was wrongly convicted, and you know the rest. So what kind of research? Well, we need to look at new types of evidence which are being developed all the time with science. We need to look at old types of evidence and discredit them if they don't have a sound scientific basis. So bite marks used to be allowed into court. They're now discredited. There's one case in the UK where Mark Gallagher, we spent 7 years in jail when an expert said he was absolutely confident that the earmark on a window was his. It wasn't his, and he was in jail for 7 years. So I think we've all got to do better. Let me give you a more recent case from the UK. You might have heard we have a criminal cases review commission in the UK. In the past 26 years, nearly 1,000 cases have been referred to it. So recently, there's been a scandal called the Post Office Horizon scandal. So what is this? The Post Office bought in a computer system, and it took ages to procure, like all computer systems. It was distributed across the UK, and post offices all over the country, sub-post offices, they used this computer system. Then a number of cases came before the courts when the sub-postmasters and sub-postmistresses were accused of fraud, false accounting, etc., because the computer system said that the amounts didn't tally in their post office. What had happened was that the computer system had fundamental flaws in it. It was ultimately owned by Fujitsu, and they denied it all the way along, but there was a presumption which applied in the UK, which is basically a modern version of machines are presumed to work. So software is presumed to work, which meant that it shifted the onus of proof on to the sub-postmasters and the sub-postmistresses, etc. And of course, how could they fight Fujitsu, who were denying it up and down the country? Anyway, it was eventually determined that there were fundamental flaws in the system. A number of the sub-postmasters and sub-postmistresses had committed suicide by this time. Well, they were pillars of the community, and they felt that they'd been humiliated in front of their communities because they regarded themselves as trusted members of the community. Since April 2021, appeal courts have overturned convictions in more than 80 post office cases. So there are more to come, and I think this is a case that's going to run and run. So once again, the rule that machines work, it doesn't work for software. You can't assume that software will work. And when I talk to the computer scientists in the Royal Society, they say no computer scientist would ever tell you that a software system would definitely work. That's why we put out patches all the time. We have to put it out there before it's fully tested in every way. So that presumption, it doesn't work for the modern world. So again, Anna Maria said, how can courts keep pace with advances in science and technology and new types of evidence presented in courtrooms? Well, I think one thing we can do is use accessible language. And one of the things that is happening now, instead of talking about likelihood ratios, etc., to the jury, you could translate it, and we've done this in one of our primers, into words which show very positive meaning, different words to describe how likely things are, so that you get away from the kinds of things which happened in the Clark case. And then we need to build good foundations. We need scientific literacy and appreciation of the scientific method. So let's come to the science and the law program at the Royal Society. So the idea was to bring scientists and members of the judiciary together to discuss key areas of common interest and to ensure that the best scientific guidance is available to the court. John Thomas always thought that the best idea would be if judges and jurors could be given primers so that they could read them away from the courtroom and understand, not become scientists, but basically understand the science to a certain level. So what we've done over the last few years is we've developed 7 primers. Some forensic gait analysis, there's no science underpinning forensic gait analysis. The use of statistics has been incredibly popular, partly because of the Sally Clark case, but also other cases. And all of the titles have been chosen by the judges themselves. They're judicially driven, and we've got one coming out soon on electronic evidence and drugs and toxicology. And they're short. They're only about this size, which is, they're all peer reviewed by scientists for the science, and they're all peer reviewed by judges for understandability in their work. And they've been translated into, I think, 8 different languages now. And part of the attraction of them is that science is the same all over the world, whereas, of course, law varies from jurisdiction to jurisdiction. In addition, we have led seminars at the Royal Society on 18 or 19 different topics now. I'll give you an example of climate change and the law. So there's John Thomas's bottom left, and Ian Dove, judge bottom right. At the top is Angela McLean, who's our government chief scientific advisor, and Eric Wolf, who's on the IPCC panel for climate change. And that traversed the kinds of cases which are coming in front of the courts based on climate change, whether it's against governments, against companies, or whatever. There are lots of other of our seminars. We've done one on sex and gender. We've done one on brain death, PTSD, and we've got one on electronic evidence on the 13th of December. I spoke about working with the National Academy of Science. Just in October recently, we held an international conference, the Royal Society and the National Academy of Science, and we talked about the approaches used by courts in their consideration, evaluation, and management of scientific evidence and expert witnesses. We had people from all over the world. There are some senior judges from the UK, the Forensic Science Regulator, and some American scientists. And we talked about AI, climate change, biology and medicine, understanding memory, all of these topics, voice, face, and hand recognition, all new. Everywhere you look, there's science, and we need to understand it better in the courtroom situation. Another example of... So the third thing we do, so we do the primers, we do the seminars, and we also are involved with judicial college lectures and continuing professional development. And we've worked on fact and fiction in brain imaging, what makes decisions autonomous, and probability in the law, substance addiction in the brain, and memory. In addition to that, we've been looking with younger people at careers at the interface of science and law, and there's a lot of interest in that, but I think we have to look at the next generation. And then we've also been running some what we call LATEs, Royal Society forensic lates, and it's surprising the interest of people in forensic science. So ultimately, what is the vision for lawyers and for scientists? Well, I think scientific literacy, a broad curriculum, so that juries better understand science and lawyers better understand science. Perhaps there should be a requirement for a basic module at undergraduate level, or at least more double degrees. Oxford's recently introduced one in computer science and the law. So I'm going to stop there. It's given you just a flavour of what we're doing. I'm very happy to answer any questions. Thank you.
Thanks so much, Julie. Absolutely exquisite. We're very, very lucky that you've been able to share your experience with us. We have an opportunity for audience questions. There are people with microphones, Lauren and Lisa, who can bring the microphone to you should you have a question. Just pop your hand up.
Thank you for your talk. It may sound a little cynical of me, but I wonder how these two joint progresses you're making can also move into the field of politics, where certainly in Australia most of our politicians are lawyers and know nothing of the environment. Would you like to comment on the likelihood that you'd be able to move your good works to include politicians?
Well, thank you for that. We do work in that space. There are very few scientifically trained politicians in the British Parliament. As you probably know, they hone their skills mainly in the Oxford Union to greater or lesser effect, in fact. So one of the roles of the Royal Society is in endeavouring to influence decision makers. And we always say decision makers, but what we really mean are politicians, by getting accurate, timely scientific advice to the decision makers. So there's no point in getting it if the debate's already been had. You've got to get it in time. And you can't just do it once. You've got to develop relationships with politicians, which is what we have discovered. Now, luckily, and we were talking about it earlier today, government does come to the Royal Society for advice. And because the Royal Society is independent and slightly scary to government, because when we say we don't like something, we do make a bit of a fuss about it, but we always try to speak to the government privately and tell them beforehand, so we wouldn't do that just without giving notice. But they do tend to come along, and we have had considerable success, actually, in getting the politicians to understand, for example, fracking and the limitations and dangers of fracking. They don't blindly follow everything we say, but we work hard to get the politicians to understand where the science is and what the risks are if they go ahead either ignoring the science or not giving it sufficient weight. So I understand that that's not quite the same relationship here, and I think you've confirmed that. But, you know, the Royal Society has been around a long time, and it was first asked for its opinion on wooden ships in 1665 by the government. And so it gave policy advice or scientific advice on policy in 1665. So I don't say we always get it right, but we do have quite a close relationship with government, and we're very mindful that it's a difficult audience getting their politicians to take it on board.
Thanks, Dame Maxton, for a great talk. And I think the research primers are a fantastic innovation. You might be surprised to know that there's still a gate case working its way through the system here, case Krupi. But so I guess the challenge might be, and it's great that you incorporate judges into deciding the topics for the primers and peer reviewing them. But I guess the challenge is that the primers themselves aren't evidence and really aren't the appropriate subject for judicial notice. So I think that for here, at least, the most appropriate pathway, I think, for getting this into the courts is through the defense's cross-examination put into the expert. Are you aware of this primer saying that this technique doesn't work? So I was wondering, and we've had challenges getting the defense lawyers to do that here. So I was wondering, as part of your program, do you also involve the defense bar and educating them about it and involving them in that process?
Yes, I mean, I referred mainly to the judges because that's where it started. But yes, we definitely do. We have practicing barristers come along, depending on the topic of the seminars. We have a lot of practicing barristers, and the primers are sent to many hundreds at the bar, and many of them are defense lawyers, and they often come in and talk to me about them. So yeah, we do that.
Hello, down the front here. Thank you for an excellent presentation. You've given compelling examples of the benefit of the law being given scientific evidence and advice in a digestible way. I find myself reflecting that both the professions of law and science are professions that value deep expertise and where we use language in very specific ways. And I find myself wondering whether it would help if our scientists had a better knowledge of the law in order to provide this support. What's your view?
Yeah, I think it's a two-way street. I think that science, at a superficial level, you can say, well, science and the law are both after the truth, etc. But you see, a scientist will say, but no, you're not really, because you think if something is beyond reasonable doubt, then it actually happened, but it might not have happened. To their minds, it might not have happened. You haven't proved absolutely that it has happened, whereas in their world, you have to repeat the experiment over and over again. So they find it quite difficult to understand that, and you can operate on the balance of probabilities as well. But they have to factor in that there's no timescales in science, and there are in law. You know, you can take as long as you, well, from this point of view, you have to come to some kind of a conclusion in the law. You have to have, the case has to finish, and you have to move on. You have to get the best evidence, but you have to decide one way or the other. Whereas in science, you can just do another experiment, and if somebody proves your experiment didn't work, then you start again, you do something else. So they don't quite see it in the same way, although you can start at that superficial level. So yeah, I think understanding how the law works and why the law has these different standards to the standard in the scientific world, it's really helpful for them. And I mean, most scientists at the seminars at the Royal Society, they will say afterwards, oh, I never thought about the law. So, you know, people who devise autonomous vehicles, I mean, we've got several of them on in the fellowship, they say, well, I never thought about who was responsible if it went, you know, and killed people. I never thought of that. I was so tied up in the science, I just wanted to make an autonomous vehicle. And these things just haven't entered their minds until later. I mean, you actually see that with bigger scientific things like the internet. And Tim Berners-Lee is a fellow of the Royal Society, and he never conceived of the internet being used for negative purposes. And he said to me he would have put in many more checks on it than he did put in, but he never thought it would be used like that. So the mindset of scientists is somewhat different, and maybe this will help.
Thank you for your talk. So at the beginning of the talk, you talked about standards for expert witnesses, the American standard systems. So are you thinking, or are the academies working towards setting new standards, or perhaps as the Australian Academy of Science did, provide or advise on who the appropriate independent expert witnesses should be?
Well, I mean, what the Dobert case basically does is it looks at the reliability and the reproducibility of the science so that you can test that it is based on sound scientific evidence. That's basically what they want. Because if you don't have that basis, then you're likely to get evidence in court which could be unduly prejudicial and negative for the whole judicial system. So the standards, this is what I was talking about with the admissibility test. You know, you've got to make sure that the science is rigorous before it goes into court, because it will be unduly prejudicial if it's not. So the standards are set in America, and the Dobert case has some flexibility in it. The standards in the UK are upheld in the main by the forensic science regulator if there's a commercial firm supplying it. Otherwise, the expert will, there'll be a hearing in limine before the trial, before a judge, and the judge will determine whether the science is robust enough to go into court. Do you want to comment from here?
Hi, Tom Crothers from the Australian Science Communicators. Thank you for your talk. There's an idea in science communication research around something called the deficit model, where there's a concept that we just keep on providing more information to people, and those people with the more information will therefore be able to make better decisions. We've seen, at least in an education sense and in a science engagement sense globally, that that's a fallacy. It's not true. I was wondering whether or not there was any evaluation that, or any evidence that you had to demonstrate that these primers and providing judges and barristers with an initial sense of what DNA evidence was actually was effectively coming to better decision making.
That's a really, really good question, and it's very difficult to provide that, because the whole point of them is not to make the judges, for example, into science, but because judges are the gatekeepers of admissibility and have to give a direction as to weight of the evidence, then if they had an appreciation of the science, which is a little better than they have at the moment, then they'll make better decisions on that. And so it's to focus the mind on the admissibility and to get away from the old days where, in the States anyway, perhaps less so in Britain, but pseudoscience was admitted into court. I think it's just calming the community down, because otherwise you'll get something that's got no scientific basis. So on the gait analysis, we deliberately did the primer on DNA and on gait analysis first, because and we're redoing the DNA one now because of advances in science. But on the DNA one, what the judges really wanted to know was, can you convict on a single source of DNA? Can I direct the jury to convict on a single source of DNA if there's no other evidence? I mean, there usually is other evidence, but this is the hypothetical. And of course, with the caveats that as long as it's not degraded, it hasn't been interfered with, the answer is now the techniques are so good, yes, you can. And that was very helpful to the judges. And on gait analysis, it basically showed, well, there's no science in gait analysis. There are people who regard themselves as experts, as super recognizers on gait analysis, but there's no science to it. It's subjective, it's not objective. So we really do want to know whether the primers have made a difference. I mean, I'm told they've made a difference. I know they've been translated into various different languages and that various courts use them. I know that some of the American courts use them. I can't draw a straight line between the two things.
Very much for the talk. It's amazing. One of the questions I've got is whether the Royal Society has any involvement in the drafting of legislation prior to its release. Because one of the challenges we find is that where scientific concepts are embedded in legislation, often there's a disagreement between scientists and the courts as to its interpretation.
Really interesting question. I mean, we have no official place vis-a-vis legislation, but our relationship generally with government departments is that if they were concerned about something, they probably would ask us. Or they would call us to a select committee, which is looking at the legislation, either in the Commons or in the Lords, and asked us for our opinion. So I quite often go to select committees to talk about things like this, but we don't have any official role. But because the government is very aware of the Royal Society and what we do, and if they get it wrong, we'd probably criticise. They'd rather have us in the tent at the start, I think, than have it later. But yeah.
Yes, thanks for that talk. It was really great, Dame Julie. I'm just wondering about the whole process of interrogation of expert witnesses who are coming into a courtroom and the potential to have someone who hasn't been prepared well because they didn't realise they need to be, or they don't understand the different approaches, which you talked about already, a scientist approach versus a legal approach. What's the way of making sure that scientific evidence gets put into a courtroom so that it's you don't end up with sort of people being led or only giving, we were talking about before just looking at the Murray-Darling Basin Royal Commission, and where an expert witness said something and then was going to qualify it but got cut off before the qualification. And so therefore the information that came through was biased, or came across as biased by those who were writing up the report. So I'm just wondering how that whole meeting of science approach, where we're trained as scientists to provide some information and then you put qualifiers around it, while I guess in a legal approach it's sort of trying to get what your evidence to follow through on a particular argument to get to an endpoint which you're trying to defend or prosecute on. So I'm just wondering how is there a place for mismatch, or is that always going to be an issue? And that, for example, if there are going to be professionals or scientific information being put forward via a witness who's been seen as expert, that there really has to be that level of preparation so you don't either get misled or be seen as an unreliable witness because you've sort of approached things in a way that could be perceived as not addressing it in a legal approach, but more in a scientific approach.
So in the UK, it would be the duty of the side calling the expert witness to prepare them, and no barrister has to let a witness go on longer than he or she wants. I mean, if they get the answer no, but you can stop and say, well, thank you, no further questions. So I think it's up to this side calling, the prosecution or the defence in a criminal case, calling the expert witness to make sure that they understand and that they need to be very careful in the words they choose at the beginning of answers to questions, because otherwise they could get into a situation where, as you describe, where their evidence is not quite what they would want to give if they'd had more time. But most barristers would know that with their witnesses, I think.
Thank you very much for your talk. It was a brilliant expose of the advance that the Royal Society has done in this interaction between the science and the law. In Australia, we have growing challenges about people who call themselves forensic scientists, And I'm wondering, when the Royal Society deals with this matter, do you have an interaction between what might be called general or other scientists and forensic scientists? Is there a growing feeling that science in general terms can contribute, but forensic scientists are people who have their daily work in the courts and preparing for the courts?
Yeah, the expression forensic scientist to certain lawyers, especially if they've done Latin, is rather perplexing, because it just means about the court, actually. But I accept your proposition. There are people who make it their business. In the UK, the Forensic Science Service was disestablished over 10 years ago. It was a service which was available to both sides, prosecution and defence. It was disestablished, and it was now there's commercial firms operate in that particular space. It hasn't been a terribly happy transition, I have to say. And I know that there are issues in this country too. So we work closely with the forensic regulator, which I think is the best place for us to start. But our real interest is making sure that however science gets into court, whether it's through Randox or one of these commercial firms, that it's the science, and they've been caught out actually where the science wasn't robust enough. Our interest is making sure that the science is robust, or the statistics or the understanding of data. In a world full of data, if people don't understand how to express likelihood ratios, etc., whether they're full-time forensic scientists or they're just called like somebody like David Spiegelhalter, for example, one of our best statisticians, then you know, the confidence in public life and in the judiciary is undermined. And once you lose that, I think it's very, very difficult to get it back. I mean, I've only pulled out 2 cases, really. Well, the ear case, but the Clark case and the Horizon case, and it has been really devastating to the confidence in the UK. And the number of cases that are sent to the criminal cases review, and there's a high bar to be sent to that because they've been through the court system. The more that happens, the less confident people will be. So our interest is getting the best science in the most understandable way, and I think we have to pay attention to the terms that we use in expressing it.
Thank you for your enlightening talk. So we've recognized somehow in our discussion that lawyers and scientists do have different ways of approaching things and the truth, and there are many other differences. Have you seen these differences manifest in your collaborations? And if so, how do you manage such differences to ensure, you know, and to facilitate cooperation, especially since we've seen how successful the work of both the law and science in the Royal Society's work has been?
Thank you. I think the thing that comes to my mind is that they start in different places. I mean, the scientists really, the scientists we work with are at the kind of frontiers of science. They're some of the best scientists in the world. And one of the key things for me is to get them to think about the law, that one day what they're doing may end up in court. So when you're developing software, I mean, I've got a committee with 4 of the best computer scientists in the UK. They all tell me, as I said before, don't ever believe anybody that tells you that software will always be accurate. We don't know that because we cannot test a system to that extent. It's not commercially viable if you test it and test it and test it. You won't get it onto the market, or somebody else will beat you to it. So for me, it's the discussion between the scientists and the lawyers, so that the scientists understand that they might one day have to go to court and answer the question, did you always know that this system might have some flaws in it? To which they would answer yes. We didn't know what they were at the outset, but we never for a moment thought they would be right. And then from the other side of things, for lawyers to appreciate the scientific method. So the scientific method is not perfect. And the science that we have today is as far as we know. So if somebody comes along with a theory that rebuts Einstein's general theory of relativity, for example, scientists would say, hey, great, that's what science is about. It's about as far as we know. If you can get a theory that's better, then that theory will supplant it, but nobody has as of yet. And so I think it's the different ways of working and the appreciation of the different professions that is most interesting for me.
Hello, my name's Bill Campbell from ANU Law School. I just wondered the extent to which the Royal Society is asked for assistance by the British government in running cases before international courts and tribunals that involve matters of science. In our own case, a number of cases we've had, for example, the whaling case before the International Court of Justice quintessentially involve matters of science. And at the moment, there are 2 advisory opinion cases on climate change, one before the International Court of Justice and one before the International Tribunal for the Law of the Sea, which also raise matters of science. So I just wondered the extent to which the Royal Society has asked for their assistance in such cases.
That's a really interesting question. We haven't been asked by the government for assistance in those cases. But I'll tell you, one of the things that has been happening, which is quite interesting, that a lot of retired judges are taking up positions in the Middle East, where they're starting common law courts. So Lord Justice Thomas, I think he's in Qatar, and Jonathan Mance, I think, has gone to Azerbaijan. So there's a bit of a proliferation of little pockets of the common law in the Middle East. And some of these judges are asking us for advice. But from the government, no, they would probably use their own lawyers, their own scientists, the scientific network, the government chief scientists, etc. But I'm not really sure how many cases. I mean, we've done some work on deep sea mining, and there's a lot of science in deep sea mining, but we haven't actually been asked for advice, but I will keep my eyes open.
That's all we have time for, okay. I'm afraid. Could you please join me in thanking Dame Julie for her contribution this evening? Thank you. It's a pleasure. If I could invite Helen Robinson, President of the Academy of Law, to offer a vote of thanks. Thank you.
Thank you, Anna Maria. I echo President Jagadish with his acknowledgement of the traditional owners of the country. It's my privilege to move the vote of thanks for our Speaker, Dame Julie Maxton, in light of an extraordinarily heavy schedule, both so far in her journey to Australia and for at least the next 2 days. If I forget to say so at the end, I hope to see some of you at the equivalent event in Sydney tomorrow evening. I'm sure you'll all agree with me, it's been a fascinating talk. Plainly, there's a keeping pace issue, and perhaps one of the things that is difficult is that it's the responsibility, probably, of the busiest judges in the local courts and the district courts who hear by number the greatest majority of criminal cases. An observation with no foundation, perhaps, but I'd like to think that in all of those courts and in the Supreme Courts, a paediatrician would not be allowed to give statistical evidence, and that problem wouldn't arise. But one of the things that occurred to me, of course, is that the education of the lawyers obviously was a problem in that case as well, because the lawyers for the other side, the defendants, should have protested, perhaps they did, but they should have protested loud and long about that pseudo-expert evidence. It's been very interesting to hear from Dame Julie about the Royal Society's work, particularly the primers that were described by her. Some of what she said and some of the questions as well took me back to the first of these joint symposiums in 2018, where we discussed at some length the differences between scientific certainty and legal certainty and the different assessment of evidence by scientists and lawyers. So my take on that, I suppose, is that there can never be, perhaps shouldn't be, a coincidence of approaches, but I think a convergence of approaches, even from the respective and different starting points of the scientists on the one hand and the lawyers on the other. So please join with me again in thanking Dame Julie very much for a fascinating presentation.